Dean of Students, Darren Wibberding. Darren's served students in higher education for over 16 years in his role, and he's responsible for managing our university's response to students' concerns and behavioral issues. And I had the opportunity to listen to Darren do a presentation in December. And it really was intellectually stimulating and made me think about a lot of different issues, our correspondence and how we interact with students, behavioral intervention team, academic freedom, for one thing, and even who owns our syllabi when we create a syllabi, who actually owns that. How the retention and appeals process has changed through the university, and I'm not sure everybody is aware that it has. So Darren has a lot of insight and guidance that he can provide to us, and I just wanted to really welcome him and thank him for coming. So really brief housekeeping. We're going to record his PowerPoint presentation session that we can post on the website, but we're not going to record questions and answers, and that allows you to ask questions freely, and it allows Darren to answer questions freely. So with that, I'll turn it over to you, Darren. And again, thank you very much for coming today.
Yeah, thanks for having me. Happy to be here. It's actually nice to not know very many people, because that means that bad things haven't happened for you with me yet. So, as we go through the presentation, if something's not clear, you want to throw it in the chat, and that'll be a good parking lot for us to get to at the end. I think that'll be great. So we'll go ahead and get started. I do want to let you know one other thing. I have accepted another position at the university. So I will be changing to a different role. I won't be going away, but I'll be doing some different things. So, but this material should still apply no matter who's in my job.
Okay.
So let's start with a quick agenda today. We'll talk briefly about FERPA, and we could probably do an 8-week seminar on FERPA. So I'll give you the nuts and bolts and sort of the things to watch out for. I want to let you know about student discipline issues, especially as they relate to the state of Tennessee and their expectations, and also our judicial circuit as well. And then talk with you about the new academic integrity process. It's shifted. The student code shifted this year. Back in October, the new code went into effect. And so the academic integrity process is just a little bit different, and kind of talk about student concerns and behavioral issues, and where to go with what. Now, my office is student discipline, right? So student accountability. So we touch on some things that might be behavioral intervention team issues. We touch on things that might be harassment, equity types of issues, discrimination. We touch on when students are accused of violation of somebody else's rights on campus. So we touch on all of these things, although we may not own all of those processes. And so frequently things come to our office where we're adjacent to them. So just kind of preface this, that I may talk about something, but that doesn't mean that I'm the owner of that process. So with FERPA, FERPA is the Family Educational Rights and Privacy Act. You all have heard that acronym before. You've heard the name before. Some of you may even be experts, since I'm talking to the College of Education in FERPA. But generally what it means is that we must have a release to give out information about a student. And the student records, the definition of a record is really, really broad under FERPA and under the Tennessee Public Records Act. So it's basically anything with a student's name or PII attached to it could probably be considered an educational record. The trick with that is that students have the right to review and inspect their records. So an email from one faculty member to another faculty member about a student with their name in it is likely to be a student record that may be required to be disclosed to the student under FERPA. So a student issues a request within 45 days, the university must comply with their request to review and inspect their record. Beyond that, the emails that you send regarding your work are business records, right? And so the state of Tennessee has business records retention policies, what stays, how long it stays, how to store it, what you must report. And then all of those things are likely, if they're not protected under a privacy law, are subject to review by any citizen of the state of Tennessee. Could walk over to the Office of Legal Counsel, present their driver's license, and say, I would like to see all of Dr. Zanskiska's emails from the month of January 2022. And we would be required to oblige. And so we would redact certain things that were protected, but we would still have to show those emails to that person. FERPA does not stop you from communicating, though, about legitimate concerns or issues to school officials who have an educational need to know. This gets a little bit tricky, especially as we have especially in graduate programs where you have a small same set of students dealing with a small same set of faculty over a period of time. What I'm going to say is just be conscientious about what you write and how you communicate that. And make sure that you're not if you are writing something, plan for it to be at the front page of the commercial appeal. And if you go from that lens, you're probably going to be a better writer for these types of things. So school officials with a legitimate educational interest. So if I call you and I say, hey, is Joe Schmo in class this week, or have they been attending, right? Attendance is an educational record. And I think generally you can trust me to ask questions that are within the scope of my job function, but you might ask, what is it that you're working on for that you need that information for? And I'll say, I'm doing a student conduct investigation. I'm trying to see if they were available or if they were actually in another location. And so I'm establishing that legitimate need. The law itself came out of maybe government mistrust of the government. Around this time, you've got Whitewater, you just finished up Vietnam, or still kind of wrapping up Vietnam. And there's just a lot going on in the country and a lot of mistrust with the government. And basically, they were trying to keep the government out of student school records, that big permanent record in the sky wasn't accessible to Uncle Sam, essentially. So that's where that kind of came from. We deal with it every day in terms of parents wanting to complain about grades or wanting to know all these things. And so students generally need that release. The other thing is that with health and safety concerns. So if you're legitimately concerned about a student's health, well-being, welfare, however you want to say it, it's okay to communicate that to the appropriate party. So if a student is having an allergic reaction in your classroom and the paramedics arrive and they're like, does anybody know if this person has allergies? And you're like, I know they have a peanut allergy, but that's written down on a piece of paper in my office, so it's a FERPA protected record. Well, you can say to that ambulance driver, that person has a peanut allergy. And so maybe somebody opened up a can of peanut butter next door. I don't know. That could be an example where you would want to communicate to someone who's not even within the university about a concern or an issue. Mental health is becoming a bigger and bigger issue every semester for us, and we're not alone in that. If you've got a student who's emailed you and they've got signs of suicidal ideation, or they're making statements and they need to do a welfare check, that's a reason to call emergency services and get a welfare check done. And you're not going to go and tell them all the things about all the grades and tests and papers they've ever turned in, but you're going to say, I have this concern and here's what it is. And that's okay to do. So just remember that whatever you write down, whatever records you keep, and it doesn't matter where you keep them. So I know some folks have their Gmail accounts and they forward all their University of Memphis emails to Gmail. It doesn't matter. If it's a record, it's a record, it's a record. It's going to be accessible under FERPA, and then it's probably going to be accessible under the Tennessee Public Records Act, and it would definitely be accessible during things like discovery, where the university is a party to a lawsuit. So just remember that your records are out there. So key takeaways from this: FERPA doesn't stop you from communicating about student concerns or appropriate officials or other folks within the university who have legitimate educational need to know. It's also okay to communicate up. So we all have department chairs or associate deans or deans or student services, various student services. It's okay to communicate up to them, but be conscientious when you're communicating with your colleagues about things if they're not truly educational need to know. If you've got a personal opinion about one of your students and you want to share that with your colleague, you might want to think is it worth it? And then if I do that, should I do it in writing? So think about who needs to know, what they need to know, and why they need to know it. And don't engage in gossip or hype about a student. Think before you write something down, and think whether you should write something down. And then also just kind of keep in mind, where are your communications, personal emails, personal text messages, etc. I certainly have a job where I'm more likely to be engaged in litigation, and I've had discovery requests that I've had to turn over some cell phone records, some text messages. And so it does happen. And they're on my iPhone. It's not a university issued iPhone. At that time, I didn't have a cell phone allowance or anything like that. It's mine, but it's a record about a student. And so then that has to be disclosed. So I'm a big Disney fan. And so this is Thumper from Bambi. And I think Thumper said it really well. If you can't say something nice, don't say nothing at all. Now, I don't want to stop you from talking because, you've got a right to do that. My suggestion is don't email, text it, voicemail it, write it down, or record it, right? Because it's going to be discoverable to someone. And then with respect to what you write, just stick to the facts, as Joe Friday would say. And I know this is the second Joe Friday. This is the one who actually made the just the facts statement. Yeah, so just stick to the facts. And I know that some of you may have advanced training or education about maybe you're in a counselor education program or psychological program. And you may have advanced training or knowledge about that, but you may want to withhold things like medical diagnosis or psychological diagnoses and those sorts of things. I suppose there might be an opportunity if you did do an evaluation or assessment on an individual, but you might want to hold off on expressing that specific opinion, but you might stick to the facts. What behaviors might another person view that would indicate that, or that could lead them to that would be a way to approach writing those concerns out. So let's talk about student discipline in the state of Tennessee. So I deal with disciplinary issues with faculty tend to be related to two types of things. One of them is about what I will call not nice students. The other is about academic misconduct. Those tend to be the two issues I deal with most frequently as they come up with faculty. Now, if I was doing a presentation in the residence halls, we'd be talking about alcohol and marijuana and visitation violations and those sorts of things. But usually that doesn't happen in the classroom. You usually don't have somebody come in drunk to class, although we've had a couple, but that's not the common issue. So the common issue I see is students who are expressing themselves in ways that are not polite, ways that you might call uncivil, and ways that you might think are offensive or that might be seen as offensive. And we have to remember that you are agents of the government. You're an employee of the state of Tennessee, and the government has limitations on the speech that it can punish. And so I'm the punishment guy, right? So there's going to be a lot of speech that meets the criteria of being rude, uncivil, offensive, distasteful, that is not actionable by my office because we apply discipline. That's not to say that nothing should or could be done in those instances. It's just that I can't punish people for that type of speech or expression. And probably if I couldn't punish a faculty member for that speech, if the university couldn't undertake the same punishment for a faculty member, they're probably not going to be able to take that punishment for a student. So I've seen some faculty senate meetings get pretty rowdy, some statements being made. I'm sure that you may have a debate that goes on within your college or your program, and you might say some heated things in an argument or those sorts of things. We're not detenuring folks for having strong opinions and expressing them like that, right? And so much the same way that the First Amendment protects you as faculty members, it protects students as well. And there are probably far more student speech cases than there are faculty speech cases, but the gold standard or the original, the landmark case for us is Tinker v. Des Moines. And like I said, talking to an education program, you guys probably have some of your education history already for educational law classes. But the original case on this, K-12 students wanted to wear armbands to protest Vietnam. The school said that is going to be disruptive to the school environment, and we can't have that, so we're going to not let them do that. And the students prevailed. It needs to show more than just the possibility of a disruption. It needs to be something that's an actual disruption to the university. And they noted that students they didn't shed their rights at the schoolhouse gates, right? So students have the right to come in. This might be a student who wears an offensive T-shirt to your class or something like that. They have the right to do that. And these are K-12 students back in the 60s. So you can imagine that as higher education has evolved and changed from being a more in loco parentis model, where the school served as your parent, your local parent. And back in the day, somebody like me would walk a student to the bus stop and say, "You're going home, kiddo. Sorry for you." That doesn't happen anymore. And so you can imagine that as education or relationships with students have changed from that parent model to a facilitator model, really, where basically the university facilitates an exchange between faculty members and students. You can imagine that those rights would be extended even further, and they would have grown. There's a more recent case, the Manahoy Area School District versus BL. This was she was a minor at the time, and so this was through her parents. But pretty recent case. This is a Snapchat case. This is a student who was not selected for a K-12 high school student who was not selected for the I think it was the volleyball squad, the varsity volleyball squad. They offered her JV, or it was cheerleading or volleyball. It might have been both, but she had some pretty choice words to say about her coaches, who were also teachers, the administrators, the school in general, her peers. And she went off, and it was public. And it's, Snapchat, it goes away after a while, but you can record it and screen capture it. And so the school wanted to discipline her for that. And the Supreme Court again ruled in the student's favor that no, this speech is protected. The student has a right to complain about their instructors, their coaches, their school, and that it didn't cause a material disruption to this campus. How could it? It's online. It's not happening in the classroom. Somebody's not standing up and hollering. So there were a number of reasons that were enumerated in that decision. But long and short of it is that they sort of reaffirmed Tinker, and I would say expanded as well to include the online speech beyond that. So the state of Tennessee is very protective of students' due process rights and citizens in general. Actually, the state has a very high bar for some other due process things as well. But and due process is this concept that you want to apply protections against making errors before the government impacts something like a property or liberty interest for a student. And so one of the ways that they have extended some additional protections to, the state has extended additional protections to its citizens, is this Campus Free Speech Protection Act. And I'll be honest with you, at the time that we were receiving, requests for feedback about the implementation of this statute, I was pretty upset with the state of Tennessee. I said, what do we need extra protections for? The First Amendment is all a person should need, right? And essentially what they did is they enshrined in law, case law, constitutional law, and put it into a Tennessee statute. But along with this, I think they put some information out there in more lay terms that literally, if you just read the statute, you would say, oh my gosh, this is what that concept of freedom of expression really comes down to when we, where rubber meets the road. And they also had some choice things to say about what faculty should be talking about. I won't get into that. I'm a student affairs guy, not a faculty affairs guy. But the long and short of that is that the state tends to want faculty members to speak on their areas of expertise and to avoid things that are not within the realm of their expertise. I think maybe the state has not interacted with very many faculty members, but yeah, so a couple of choice things that I pull out of this statute, and I've got, Steve has a copy, and I can drop off a copy in the dean's office over there as well for just kind of sharing, but basically they affirm that college, universities are sort of this place where we're supposed to have these debates and exchanges, and that we're going to have disagreements. They want this to be that ground where these types of things are, as I would say in Texas, where I was at a little while, cuss and discuss these things, right? And that we, as the government, as the agent of the state, are not to suppress that free exchange because of our opinion about what's being talked about or our perspective about a specific viewpoint. And then they also don't want us to shield people from speech, right? So you may hear things that you do not like and that is offensive to you or is disagreeable. however you want to call it, that you know that person is wrong when they're telling you these things, but it's not our responsibility as the state to shield a person from that. The best response to speech you do not like is your speech. And so the state has really put that out there, and they require the university to have a free speech policy. They require us to publish it on the website. That's other parts of this statute. So some things to think about there about even access to campus. What is a public forum? Who gets to talk where? And this is something where I want to talk about in terms of classroom, especially, we were doing a lot of online teaching before COVID, but even more so now where we have, I was going to call it D2L, but Canvas classes, and you may have discussion boards on there. And one of the things I worry about is for faculty members who have discussion, you're doing it out of the kindness of your heart. You're posting a discussion board that says, whatever you want to talk about on this board, we're open, we want to hear. And I think you do it out of a great place, a caring place. But essentially what you've done is you've created a public sidewalk in your online class. And so when you start to attempt to shield others from that speech, or you want to discipline someone for the speech that occurs in that board, you've opened yourself up to have that essentially public sidewalk in your online discussion. So important to limit your discussion to specific topics or specific types of content even. That's not to say that, if you have a touchy subject out there, if you're going to talk about maybe the impact of Roe v. Wade on college student success, there might be something to that. There might be a trend or a pattern that you're able to see or make a connection to. And then you've got students and you're talking about abortion, they might bring in some things and some viewpoints. They're going to have the content, right? They're going to talk about the abortion piece, but their viewpoint may be concerning or offensive to others. And so just need to be very conscientious about how we approach those types of things and opening up those conversations, being able to moderate them appropriately, and not discriminating based on viewpoint, but discriminating based on content, right? It's okay to do some limitations, but you have to be conscientious that it can't just be a limitation because you don't like what they're saying or their perspective. The state of Tennessee, I find this interesting that we passed this legislation where the state was very concerned about students' free speech rights. And then they try and expel a student from the University of Tennessee Health Sciences Center for exercising her speech rights. So it's interesting to me that we have these opposing opinions. I would really love to ask the Attorney General's office why they would defend this suit for this student. But this is a student literally just down the road who's suing about a free speech issue. And so I think it's interesting, and I hope you will too.
I am suing my university because they have violated my rights to free speech as granted under the Constitution. So this also...
Oh, I'm so sorry. I tried to mute myself.
Sort of started back in 2019. It was around September. I got an email just saying, we're bringing this case against you before the professionalism committee. So initially it was just, to my knowledge, an Instagram post that had sort of set things off. And they scrolled through my whole page and didn't give me any specifics, but said, oh, well, this is sexual. So I tried to conform to their needs and wants at the time. So we go through that whole ordeal. They give me a warning. I had to write a letter saying, basically, I'm sorry, I won't do it again, and this is what I'm going to do in the future. Not even a year later, got another email. Same stuff. They just sent me pictures, didn't tell me what I did wrong. I asked them, okay, well, why can't I say these things? Or where in the policy does it say I violated any of the rules? No response to those questions. Had another meeting, and then they said they wanted to dismiss me from the program. So then I had to go through a whole appeal to our dean. I don't know if she necessarily agreed with me, but she allowed me to stay and said, hey, just try to keep your social media as private as possible. I'm not doing these things on the clock while at work. Once I'm off the clock in my home, leave me alone. it's so important to me to just have my voice, because people that look like me are often told, be quiet, stay in the back. And that just does not suit my personality. I'm not going to go through this a third time during my third year. So I wanted to move forward and sue them so they know not to mess with me and don't do this again to anyone else.
So my point is not to scare you and to make you think that you're going to be sued tomorrow or anything like that. These cases don't happen every single day. It's not, I like this because it's local, right? And it's in our backyard, and it's for you all, it's another graduate program who's attempting to respond to concerns about professionalism, right? You all have ethical codes or standards or professional standards as part of your national organizations, which may be linked to your licensing, and there's a lot that goes into that, right? And so you are turning out professionals. So there probably is a greater sense of your responsibility as a gatekeeper to a profession, or protecting the public interest, right? And so, not to say that you can't do that, but we have to be conscientious about how we approach these things and what we're actually talking about, sticking to the facts on those cases. So let's talk about due process protections. So we've got the First Amendment. So we started with First Amendment, and now we're going to move to Fifth and 14th Amendment down the Constitution. So Fifth Amendment says no person shall be deprived of life, liberty, or property without due process of law, right? That only applied to the federal government, national government, until the 14th Amendment came in and said, nor shall any state. And so then all of a sudden we get all of these protections at the state level that were at the national level. And again, you all are agents of the state, and students have interests in their classes, right? So they pay for their classes, so there's a property interest there. They may have committed sometimes an exorbitant amount of money towards getting their degree. Not to just say that because they paid, they get it. They still have to meet the academic standards. But then they also may have a liberty interest as well, in terms of what being branded a cheater or unprofessional might do to their possible future earnings, their possible ability to engage in the job or profession they want to get into. And so we need to be conscientious that due process is there to prevent errors on the part of the state in those decision-making situations. And there are going to be some times where it may make sense to consult my office, especially about conduct that fits under the student code that may also be an ethical standard, to let our office provide a very high level of due process, and use that process sometimes to sort out all the fact finding, and then let your folks deal with, on the retention committee side, the parts that they're knowledgeable about, which is that if these facts are true, here's how they fit within our ethical standards, and here's the decision that a program might make. So I get to decide, or not I, but the student disciplinary process decides things like if a student stays in school or not, which is different than if a student stays in a program or not. Arguably, kicking a student out of a program might be a liberty and property interest similar to, this is a debate that we have on our campus. Is it the same? It's not quite the same, but I think a person could make a reasonable argument that it's just as bad, just as detrimental. So upping some of those procedural protections to make sure that when we make those decisions, I'm not saying that it stops us from making the decisions, but we have to go through the process to make the decision. And that's important. We have some Sixth Circuit law as well. So we've got national law. Now we'll move down to Sixth Circuit. We are in the Sixth Circuit, which includes your colleagues in Michigan and Ohio and Kentucky. And let me tell you, Michigan and Ohio, hotbeds of student conduct, student issues, always have been, maybe always will be. And I feel for them, but every time one of our friends in Michigan and Ohio mess up, it impacts us a little bit, right? And so this is a case, Doe v. Baum, was a 2018 case in the Sixth Circuit that says if a student is accused of misconduct, we must hold some sort of hearing before imposing a sanction as serious as expulsion or suspension, right? We know that those two items are property and liberty deprivation pieces. And it's not going to be very hard for somebody to say that removal from program is a liberty and property deprivation. And then they went on to say, it's not even good enough to just hold a hearing. And when they say hearing, they have ideas about a hearing. They don't mean that the accuser, in a small program, maybe you've got a program of 3 or 4 faculty and you have a committee of 3 or 4, and the accuser is also one of the panelists on the committee. They're going to say that's conflict of interest. That's not going to fly. You can't have the accuser being, you can't be judge, jury, and executioner, and the complainant party, right? So they have thoughts on what that word hearing means. And they go on to say that it's not just sufficient enough to have a neutral third-party objective review of this, that if there is something that turns on credibility, and think about how much of our dealings every day are about credibility, right? It's about what somebody says, what 2 different viewpoints might be on the same situation, same setting. Even when there are things like videos, it doesn't capture everything. And so if determination about a finding relates to somebody's credibility, then you need to include things like cross-examination, right? So our student code is written to incorporate some of that into our processes, but just to let you know, if you get into an academic misconduct case, and we've certainly had our fair share over the last couple of years, especially with COVID, and we've had students come with attorneys and they're saying, you're branding my kid a liar and a cheat, and you're trying to take away this grade from them, and we want to, we're going to question the faculty member, right? And so being able to recognize that some of these things are coming down the pipe for you, I think to prepare for that, to understand why it is what we do, is important. So I think what we'll see as a trend is increasing due process requirements for universities, public universities especially, and even some private ones. There's some cases, there's a case that happened out of Rhodes a couple years ago, where in a Title IX situation, they expected Rhodes, which is a private institution, to apply public institution due process requirements in a setting. And so I think we'll see more and more of this happening. All that to say the grass is not greener on the private side. And then as a state, we also have what are known as agency rules that are developed through a process under the Uniform Administrative Procedures Act. So we have a new student code, and it went through rulemaking. I had public hearings. I met with the Faculty Senate quite a number of times. I got their approval. I met with Student Senate. I got their approval. I met a lot with our students' courts members and faculty members who serve on our committees to develop a new rule. And it's called a rule under the state of Tennessee. And because it relates to the discipline of students, which impacts their property interests, their liberty interests as well, it has to go all the way up through the state legislature to get final approval. So I went up to the state back in the fall semester, and it got approved and then was enacted on October 18th. What that does, though, is it creates an administrative law essentially for our campus. So it takes these bigger ideals, the constitutional ideals, the statutory ideals, and it applies them directly to, like I said before, rubber meets the road. So all that to say is that our student code is now consider it the law of our campus, essentially. It is an agency rule, and we need to do those things in the way it says that we're supposed to do them. And if we don't do them, then we should expect that our decisions might be overturned at a minimum. So there's that. Let's talk about academic misconduct process, and not that dissimilar from the old process. I think people are going to be a little bit kind of taken aback because there's a change, but it really starts the same way. There's going to be a notice to a student. I've got that information on our website. I've got a template that you can use. The student and the faculty member are going to talk or hopefully meet about that situation and try and figure out what's going on. A lot of our students are pretty honest about, yeah, I got caught up in time and I copied and pasted. I meant to change it and I forgot to, and I just, ran out, and I'm sorry. It'll never happen again, right? You'll say, okay, but you failed that assignment, and I got to report this to our office, right? And if that's how that goes, that's great. The student gets their academic penalty from you. They get their behavioral penalty from me. We do an educational module. We've added that. That's new for this year on the first go around. The old process actually required that a student have multiple violations before they got discipline from our office, which not something I like. If I can Barney Fife nip it in the bud, that's what I want to do. And so we're adding on an educational component to the first part. And if the faculty member and the student agree, great. You're going to check with my office. Hey, Darren, is this the first violation for the student? Most likely it is. Most of our students don't recidivize that we know of with academic misconduct. And so we'll say, yep, it's first time they get the warning in the educational module. I've got a form that everybody fills out and signs, sends it over to my office, and you're done. And this changes from, well, the department chair sends out a notice, then they get to appeal to the department chair, and then they get to appeal the academic integrity committee, and then they get to appeal to the University Committee on Student Conduct. Oh my gosh, so many appeals, right? So the last process was just like Appeal Central, and it was very burdensome on the department chairs as well. So basically, if the student agrees, great. If the student disagrees, great. Send it on over to our office. We will take it and we will treat it with the same process that we provide to behavioral discipline. So I'll assign somebody to investigate the case. If the student doesn't agree with our perspective, they have a right to a committee hearing. We essentially call the faculty member as a complainant or witness in that process, and the committee renders a decision. I'm glad to see that there's some staff on here today. The committees used to just be faculty and students. And I think we forget that a lot of our, staff are the third branch of government for campus, of shared governance. And so I want to honor that. I also want to honor that staff interact with students a lot, and they have perspectives on this, and that we have some very capable folks who work on our campus who are not faculty members who can engage in these educational conversations with students. And it helped me fix the problem of the faculty senate wanted 2 faculty members on the committee. The student senate wanted 2 students on the committee. And so we ended up with 1, 1, and 1, right? And so we were able to compromise as well. And that's a nice compromise there. So basically, we'll take on the burden at that point when it gets referred to us of handling that case, and we'll call the committee or the faculty member in. If we don't understand the case, we'll call them in to tell us about it. And then, if it goes to, we'll go all the way to a committee hearing. The appeals process in this particular new process for academic and behavioral is a paper appeal. It goes to a separate appeal reader. All the appeals used to come to me first. That was a little rough. And so we've also limited some of the bases as well. So just because you don't like a decision is no longer a reason for an appeal, which for anyone who's ever dealt with appeal processes on campus, that's usually the number one appeal reason is I just disagree. So hopefully we want to limit those down because we've done such a good job on the front end with the hearings. By the way, I've got forms, and this chart here and an additional flow chart are all on our website. Memphis.edu/OSA. If you go to our For Faculty tab, the links and resources are there. Classroom management. This is something where if I could, I would have the College of Ed train all of our faculty members on things like classroom management and pedagogy, right? You all might be the only folks who are trained in these areas as part of their discipline. And so maybe that's something we can do in the future, but it's something that a lot of folks struggle with. If you're a great physics instructor, maybe you're just great at physics, and that's how you got to be a faculty member, not because you're a great teacher or maybe you're a great researcher. And so I worry about, I'm not picking on any department or anything like that, but I worry that we don't always set everybody up for success when we don't give them the skills and tools that they need in order to effectively do their job. We just sort of assume, right? And so I think that's where I also get some referrals where people are very upset, and rightfully so, about how they were treated or how a situation went. But then you're asking the guy who has probably the most limits in terms of what he can do to handle that, right? And there's going to be a void. There's going to be, maybe not a void is the right word, but there's a gap between acceptable behavior. Then you've got sort of uncivil, unacceptable, unpolite behavior. And then you've got behavior that's disciplinable. And then you've got, beyond that, in that discipline range still is, dangerous behavior, right? So my process only starts at the disciplinable behavior, but there's a lot of stuff that occurs before then that we wouldn't like to have happen. And so figuring out, who's responsible for nurturing our students and developing their frontal lobes and working through some of these challenges. And I think that that's something that we all have a responsibility for. If someone treats me poorly in my interaction on campus, I'm the big bad dean of discipline. you would think I would just go, "You're out of here, kiddo." I don't get to do that, right? And neither do faculty members, right? So understanding who and how to approach that behavior. Now, that's not to say that you lose control of your classroom. I don't want anyone to hear that from me. If a student is disruptive in class, you have the right to remove them. The challenge is sometimes you give them a kick on the way out the door that says, "And don't come back." Well, that's actually starting to get into the property interests of that student. So then we have a process for that, where if there's a disruption in the moment in time during a class period, you have the authority to handle that. That's your classroom. If a student won't quit talking about a subject or stands up and hollers, I've even had a student throw a chair in the general direction of another student, right? I mean, there's lots of crazy things that can happen. But if it does disrupt the classroom environment, then we can intervene in that moment to stop it, and we can intervene in the future to stop it. But that becomes a discipline issue that we work through. Concerning behavior, I talked earlier about mental health concerns being a more serious and severe trend on not just our campus, but all campuses, and reaching out to the Dean of Students office, who handles the behavioral intervention team, who also supervises the campus counseling center, letting us know about those concerns early so that intervention can hopefully get taken care of, and maybe we can resolve some of those problems before they become bigger issues or before they become discipline issues, right? Knowing how to respond to disruptive behavior and when we might respond to it and what to do in the moment, and knowing who to refer it to. So I'll take the disruptive behavior referrals, right? And work on those through our office. And then dangerous behavior, if a student is making a threat, or you've got somebody who's brandishing a weapon, or there's something else that's going on that makes the environment dangerous, unsafe. A lot of people have wanted to call me, and a lot of people have called me, and I'll say, "I need you to call 911, right?" Or, "Hey, you're saying that this person needs a welfare check." It's me going to someone's front door. I'm not going to be able to do anything, but maybe we need to send the crisis intervention units from the community out there. So knowing who to reach out to in those moments is important as well. I think a lot of you all, just through the nature of your training and education as part of your discipline, are excellent at de-escalating and diffusing situations, and recognizing that you can take a step back from a situation and evaluate it rather than sort of entrenching yourself in it. But some folks have more difficult times with that. And so being able to practice that skill and use it helps us quite a bit in the student discipline side, because the first thing a student is going to do if they're being disciplined is also make a complaint about the person who's making the complaint about them, right? And we've had situations where it's the two wrongs don't make a right, right? And it makes it more difficult for us to do our job if we're also having to focus on the behavior of the employee. A big one for me is understanding what, for lack of a better word, ticks you off, right? There's other words I would like to say, but I'm being recorded. But so, what are my own triggers? What gets me hot and bothered about something? Mine is timeliness. When a kid is late or student is late to my hearing, it automatically just sets me off in the wrong way, right? That's something I know about myself, know thyself, right? And so I have to kind of take a step back and go, they've got a life too. They've got a lot going on, and they're learning. These are new skills for them. Maybe they don't know how to set alarms or whatever it is, right? Or whatever emergency happened to them that day. So understanding and sort of setting your emotion aside to continue to do your job, and then maybe returning to it later on. If you've got a student that comes in 15 minutes every day and they make a bunch of commotion, sitting down their backpack and unzipping their jacket and setting up their computer and it dings. There's a lot that goes on that impacts your classroom there. Figuring out how to respond to that student and when to respond to them is going to be key to resolving that issue moving forward. And so that's kind of taking that step back and figure out what's going on for that student and what we can do to get the best resolution possible. And this is where I talk about time, place, and manner, right? If you've got a student who comes in late and you shout at them, "Why are you late? Sit down, shut up, I don't want to hear you," right? This would never happen, I'm sure, in your area, but thinking about how that impacts the student, how that impacts the community, and figuring out when is the best time to address a concern and how to address it is pretty important. Also, another big thing about student conduct is that accommodations must be provided to students. And if they are not, it becomes very difficult if an accommodation is required and not provided and the student acts out in that class. It becomes very difficult to take disciplinary action. So please work with my dear colleagues over in DRS if they have an accommodation that's been approved for our students to provide it. Non-academic misconduct, it's about the same process now, is that we receive the complaint, we invite the student for a meeting, what we call an educational conference. We show them what's been reported to us. So this is, again, be very conscientious about what you write and send, because you're going to be, it's reasonable that a person who's been the recipient of a student's poor behavior, it's reasonable for them to be upset and have emotions and have thoughts about that individual person. But if you express those in that report, like, they're going to read it. And so beyond the fact that the student did X, Y, or Z, you've attached all your thoughts about that student, and they're going to have to see it as part of their due process rights. And if they didn't have the due process rights, they'd still have the educational records rights. And if they didn't have the educational records rights, they'd still have the public records rights. So there's a lot of ways that information gets back to the student. So just be conscientious. And I've tried to reply back if you get an email from me that says, can you call me? It's because I am trying to help you, I promise. And if you get an email from me that's like, let's not discuss this over email, I promise I'm trying to help the institution. I am never trying to get faculty. I'm never trying to get anybody in trouble. It's work for me. I'm trying to help us avoid pitfalls and concerns. I want to honor that people can be very upset and they have a right to be about what happens to them. But I have to be dispassionate about our process and how we handle things. And so the more you can help me help you, the better. So inappropriate or uncivil behavior, I think for me, this is a community responsibility to address, right? I've done it. I go over to the campus mailroom almost every day. I have a post office box over there. And I cannot tell you how many times I've interacted with a student who's just been a jerk to the mail clerks, right? And most of the time I don't even introduce myself or say I'm Darren, I work in student conduct, yada, yada. I just apply a little bit of, hey, I don't know that that's how you meant that to be. Did you understand that person has a lot going on, right? And, I'll engage in those conversations. And there's been times where I've pulled a student aside. I saw a student call the mail clerk an a-hole. They use the whole word, and I pulled aside and said, I didn't grab, but hey, I need you. I want to talk with you over here. I want to, I understand that you're concerned. I want to hear your concern, but this isn't how we talk to people, right? Not disciplining them, because the one act alone is probably not enough to make a student conduct case, but I think it's a community responsibility. Concerning behavior, you want to talk with the Dean of Students Office about that, student health and counseling services. Disruptive behavior, let me know. We want to maintain that learning environment on campus. That is our legal mission, is to educate and to have those environments where we engage in learning. And then dangerous behavior. I'm not your first call if something is dangerous, right? It probably needs to be law enforcement, emergency services, depending on the type of situation. I might be your second or third call. And so just knowing who to call when. So that's it. That's my presentation today. I know that there are going to be questions, so happy to take any questions. I'm going to stop the share. If you need to get a hold of our office, memphis.edu/OSA, this 2298 number is our main line. Now that's my email. Like I said, I'll have a different role on campus, hopefully in the next month. And so I will not forget what I used to do. So I'll forward you as appropriate, or if I can answer it, I'll just answer it. But I plan to still be available for consultation, those sorts of things. So thanks for your attention. I'm going to stop the share. And if you have any questions, just raise your hand or talk. It's a small enough group. I think you can just open